in case you missed it on Newsbreak.
For those who've been following our trajectory, we actually did launch the application quite some time ago. Numerous delays which we would submit were not on our account led to the matter being heard much later than it should have, but we're actually extremely pleased that this matter now has finally reached the High Court and that everything in our submissions is going to be heard on its merit. And this is going to be of great relief not only to us as an NPC but also on the many who we represent. As we've always maintained, our action is actually on behalf of everyone because we fight to preserve the constitutional rights of university stakeholders across the country. We have in excess of several thousand followers across social media platforms, and we're mandated to legally represent more than 500 university stakeholders nationwide. So this is going to come as quite a relief to everyone whose rights are contingent on the outcome of our action.
The policy is not presently in force though, so why is persisting with legal action something that the organization is continuing in?
There are two things that need to be considered. The first is the fact that there is a substantial number of stakeholders who actually were adversely affected by the policy, and many of them are still actually suffering the effects of the various forms of prejudice that they suffered to this day. This is recorded on affidavits, of which we have dozens, and so the application is being brought on behalf of these persons. The other point worth mentioning is the fact that the policy remains extant and can actually be re-implemented as the university sees fit. And so these questions of rights and of the appropriateness of these measures and of their exercise of public power needs to be answered.
Let's go a little bit deeper when it comes to those who have been affected. How would you say the policy has affected students in terms of access to education?
The policy denied unvaccinated stakeholders access to campus. They were able to provide negative COVID-19 tests at their own cost. And obviously, when one considers the fact that the majority of students at the University of the Free State are actually dependent on NSFAS loan funding for their studies, paying 500 Rand a week, which is 2,000 Rand a month for a PCR test is completely prohibitive, considering that many of these students are actually living below the breadline and can barely afford to actually pay for their living expenses and studies, much less the added expense of a test. And so many of these students, and they have stated this on affidavit, actually had to vaccinate against their will or alternatively be denied their access to education and refrain from attending classes because there were simply no options available for them.
So what then do you hope will be the outcome of the matter?
So the relief we're seeking is essentially to demonstrate that the adoption and implementation of the policy was at odds with the evidence available at the time, was disproportionate, and actually entailed a violation of rights that could not be justified in terms of the outcome that they sought. And this is actually reflected in the fact that the majority of tertiary institutions who actually paid attention to the evidence at the time actually did not implement similar policies, even though they might have been considering doing so at some point. And we can similarly look to the fact that the government itself didn't actively implement measures that discriminated against unvaccinated persons or denied them access to public spaces.
Newsbreak, Lotus FM, powered by SABC News.